Hello friends, welcome back to a new video. So friend, today in this video I am going to share with you the concept of delegated legislation, which is one of the topic or subject of the subject administrative law. So here we will cover all the important aspects related to the delegated legislation, which covers its necessity, its constitutionality and how it can control over the delegated legislation. So let's see what are the definition of delegated legislation. So although it is very difficult to define the actual meaning of the term delegated legislation, but yet an attempt has been made by the various jurists to define it in the various forms. So firstly we see, according to the Professor J. Mukherjee, delegated legislation is an expression which covers a multitude of confusion, and it is an excuse for the legislators and a shield for the administrators and a provocation to the constitutional jurists. According to the Professor Salmond, legislation is either supreme or subordinate, whereas the former proceeds for sovereign or supreme power and the latter flow from any authority other than the sovereign power and is therefore dependent for its existence and continuance on superior or supreme authority. We can also say that the delegated legislation is a legislation made by a body or a person other than the sovereign in parliament by virtue of powers conferred by such sovereign under the statute. A simple meaning of the expression delegated legislation may be given in the form of as when the function of a legislation is entrusted to organs other than the legislature by the legislature itself, then the legislation made by such organs is called the delegated legislation. So what are the methods of judicial control over delegated legislation? Judicial control over the delegated legislation is the most outstanding controlling measure. It can be exercised by applying two tests. First one is substantive ultra vires, and the second one is procedural ultra vires. So when subordinate legislation goes beyond the powers of the authority vested or conferred on the delegated to enact, it is known as substantive ultra vires. I want to repeat it again. When subordinate legislation goes beyond the power of the authorities conferred on the delegate to enact, it is known as substantive ultra vires, and it is a fundamental principle of law that a public authority cannot act outside the powers and purviews, and if the authority acts, such acts becomes ultra vires, and accordingly it is to be held as the void. And when a subordinate legislation is enacted without complying with the procedural requirements prescribed by it by the parent act or by the general law, it is known as the procedural ultra vires. In case of procedural ultra vires, the court may or may not quash delegated legislation, as it depends upon the circumstances whether the procedure is to be held by the mandatory or directory. It is to be noted that the judicial control over delegated legislation is exercised by applying the doctrine of ultra vires in a number of circumstances. Now, what are these circumstances? The first circumstance may be where parent act is ultra vires for the constitution. That means the first main point is when parent act is ultra vires the constitution. The constitution prescribes the limits within which the legislature can only act, and if the parent act or enabling act is ultra vires the constitution, the rules and the regulations made thereunder would also be declared as null and void. The second consequence is where delegated legislation is ultra vires the constitution. Now, under the certain circumstances, it is possible that the parent act may not be ultra vires the constitution, and delegated legislation may be consistent with the parent act, yet the delegated legislation may be held invalid on the ground that it is ultra vires the constitution. Third important consequence is where delegated legislation is the ultra vires the Parent Act. The validity of the delegated legislation can be challenged on the ground that it in excess of powers conferred by the Parent Act. The last consequence and the main fourth important point is the where delegated legislation is in conflict with the prescribed procedure of Parent Act. Again, it is to be noted that the validity of the delegated legislation can also be challenged on the ground that it is in conflict with any provision of the Parent Act. Now we see what are the constitutionality of the delegated legislation. Article 245 and Article 246 of the Constitution provides that the legislative functions shall be vested in Parliament and state legislature, and they shall exercise their legislative powers with respect to entire entries mentioned in Union and state list respectively. That is nowhere mention of any clause whereby it can be concluded that the legislature cannot delegate the power of legislation to anybody else. But it does not mean that the powers of legislation include the power of delegations as well. In the Constitution itself, we find several provisions where the executive heads, that is the president and the governors of different states, have been empowered to make laws under certain conditions when the parliament of state legislatures are not in session. Moreover, the president's rule in any state has also been authorized the executive to make laws. Therefore, it can be concluded that the intention of the constitutors makers was that the function of the legislation must be carried out by the only legislature in centers and states. But now, in view of this discussion, we can state that how the position of in India it covers. The position in India is that the legislative functions in its true sense and agents cannot be delegated. Therefore, what can be delegated is non-agential legislative function, and the question is decided by the court as to what are the agential and what are the non-agential legislative functions. The agential legislative function consists in formulating a policy of law and the legal principles which is the basis of rule of conduct of individuals and officials of the state. Therefore, it is now settled that what can be delegated is something which does not constitute the agential legislative function. Now, the following functions cannot be delegated, which I am going to subsequent understand you. That what are the functions which cannot be delegated under the delegated legislation factors. So, the first one is agential legislative functions. Although there is no specific bar in our constitution against the delegation of legislative powers by the legislature to the executive, now it is now settled that the agential legislative function cannot be delegated by the legislature to the executive. Second one is repeal of law. Power to repeal a law is very agentially and the legislative powers, and therefore delegation of such a power by the legislature to the executive is declared as ultra vires. Third is retrospective operation. The legislature has a plenary power of law making, and in India the parliament can pass any law prospectively or retrospectively subject to the provisions of the Constitution, but this principle cannot be applied in case of delegated legislation. Giving an act retrospective effect is essentially a legislative function and it cannot be delegated. Next one is future act. Legislature can empower the executive to adopt and apply the laws existing in other states, but it cannot delegate the power by which the executive can subject or adopt the laws which may be passed in future, as this is essentially a legislative function. The last main important points in this regard, the function which cannot be delegated, is the ouster of jurisdiction of courts. The legislature cannot empower the executive by which the jurisdiction of courts may be ousted, and because this is a purely legislative function. So this is the main concept of the delegated legislation as to in what circumstances it can be delegated, and in what circumstances it cannot be delegated under the Indian Constitution, and how it properly works. So friends, this is the basic concept that we discussed today in this by the help of this video. So friends, if you have any comments in your mind regarding this video, please mention it in the chat box so that I will respond there too. I hope you like this video. Please share the video with others, and don't forget to subscribe my channel for getting the new updates on this channel. And with regard to other videos on this topic, you may go to the playlist of the administrative law, where all the videos regarding the subject of administrative law is available. Thanks for watching this video.